After calling only 2 witnesses to the stand, the defense rested its case Tuesday afternoon in the murder trial of George Anthony Dominguez Jr. Tuesday morning was filled with the testimony of David Stock, who admitted to not seeing who fired the fatal shot the night of Whelan's death, but said Dominguez later confessed to him. Stock at first wouldn't answer questions about his trips to the Whelan residence and invoked his Fifth Amendment right to not incriminate himself.
You've been down there before on multiple occasions, haven't you? Can you talk to your lawyer?
Yeah.
Steve, why don't you just stand in line?
I'd like to invoke the Fifth Amendment.
And you've been down there with Savannah and Red before, haven't you?
Prior, no. I'd like to provoke that Fifth Amendment.
You've been down there with Red and Michael and Brandon Howerton, haven't you?
I'd like to provoke the Fifth Amendment.
So that the jury can hear this information, we will allow him use immunity, which is that his testimony here today can't be used against him, though others say.
I know for myself and for my family, we did not kill anybody out there, and we went out there and something terrible happened.
Yeah, and you don't know who
It
did it.
stayed with us. It's still with us.
You don't know who did it, do you?
No, sir, I'm not.
You weren't there, were you?
I was there, but I didn't see anything.
All right, on any of the versions that you told, you never claimed to have seen anybody pull a trigger.
No, sir.
You never claimed to have seen anybody fire a shot.
No, sir.
So you don't know who killed Mr. Whelan, do you?
I don't know.
No.
Dominguez faces numerous charges regarding the late January 2012 shooting death of William Whelan, but his most serious charge of first-degree murder may not be up to the jury to decide. His attorney, Michael B. Bernays, argued that for the charge of felony murder to remain, the prosecution had to prove that Whelan's death occurred during the commission of an allowable felony.
Well, the state may be able to proceed on second-degree manslaughter and endangerment and all the other charges that are not based on this felony murder theory. The felony murder itself cannot stand because there was no burglary during which, in the course of the furtherance of Mr. Whelan's time.
Burglary was ultimately culminated the next day, but it was the attempt, which is a valid basis for felony murder.
In the state's case, in this matter, they just don't have a burglary of Mr. Whelan's house during the course of or in furtherance of which his death occurred. There isn't any evidence of intent to commit a theft or other felony at Mr. Whelan's place. It's just a stupid, regretful shooting.
Okay. Thank you. Well argued.
Judge Holt is expected to announce his decision on Bernays' motion Wednesday, which will also feature final arguments from both sides and final jury instructions. This has been John Johnson reporting from Safford for the Eastern Arizona Courier.